Welcome back to Just Liberty. I'm Alan Reinach, president of the Church State Council, with my co-host Bettina Kraups, editor of Liberty Magazine. And we are giving it our best shot to take back liberty from the political extremes. But even the political and religious extremes enjoy First Amendment protections to freedom of thought and freedom of speech, don't they?
Correct.
Or do we just want to protect freedom for the speech that we agree with or that we like? This case, I think, is going to be controversial, the story we're going to talk about today, because the speech at issue is speech that clearly is controversial and not everybody agrees with. And it reminds me, one of the very best book I've ever read about free speech was published by longtime New York Times opinion columnist Anthony Lewis, and it was called Freedom for the Thought We Hate. And it chronicles, Bettina, decades and decades of Supreme Court decisions and how the court managed to find value in free speech, even for unpopular speech.
This is such a tricky issue, Alan, because we all agree with free speech in theory.
In
I mean,
theory,
we all,
right.
in theory, it's a fabulous idea.
Just like we believe in religious freedom in theory, as long as it's our own.
Exactly. But the point of these First Amendment protections, they only exist because we don't like certain ideas and we don't like certain actions. And minority views, even if they're offensive, they need to be protected from majority
oppression, suppression.
Exactly. That's the word I was looking for.
Yeah.
Yes.
So, I think it was Oliver Wendell Holmes who drew the boundary, used the illustration of falsely crying fire in a crowded movie theater and so he causing a stampede where people are going to be injured. There is speech that is harmful. There's speech that incites to violence. There is defamatory speech. So, there are, as with all of our rights, there are limitations on them. But I don't know that we're going to I don't think this case is about limitations. It, unfortunately, is really about procedure, isn't it? But why don't you go ahead and introduce our guest, and we'll get into it.
We are delighted today to have with us Nate Kellum from the First Liberty Institute. He's senior counsel there. Prior to coming to First Liberty, he was also the founder and chief counsel of the Center for Religious Expression. Thank you so much for joining us, Nate.
Oh, it's my pleasure.
So we are talking about a case that was granted cert by the Supreme Court earlier this month, Gabriel Olivier. Now, Nate, why don't you walk us through the facts of this case? Just establish sort of the background of why we're here.
Certainly. Gabe Olivier, he lives in Brandon, Mississippi. And so what he wanted to do was to go to the park and to be able to tell people about Jesus and other things regarding the Bible. And so he goes out there for that purpose, but he's told that to do so, he actually must go into this chalked off box that is about 300 feet away from where he could really reach anyone. And so he goes over there, he takes a look at it, and he quickly surmises that, well, this isn't really workable. No one can really see me. No one can hear me. And so he goes back to where he can find an audience for his message. But the chief of police arrives, and he tells him he has to leave. He has to go back. Gabe tries to engage him in a conversation regarding the constitutionality of the restriction. But the chief really had very little patience for that discussion. And so he arrested Gabe, and then Gabe in turn paid a fine and wanted to go back. And so that's really kind of the underlying concern, Bettina, is that he was arrested and he wanted to go back. And then that's when he tried to challenge this law in court.
So this sounds an awful lot, Nate, like the free speech zones that have been challenged on college campuses, on public university campuses, where they're like, okay, well, we have to allow free speech, but we can have time, place, and manner restrictions. And so we're going to put you out in the boonies where you really aren't going to be a bother to anybody. Is that kind of what's going on here?
No, that's exactly it. It is a boony law. Basically, put the speaker in a place where he can not be heard or seen, and that seems to be the whole idea about it. That you're. I think they acknowledge that he has a right to free speech as long as he doesn't connect with anyone.
So you
And
mentioned the amphitheater, and I'm originally from New York City, and in Central Park, there's a lovely amphitheater where they would hold all kinds of, music concerts and other kinds of programs. It's a very popular spot, and I can see where, he might need to apply for a permit and, to be able to use the amphitheater, for example. But outside of a venue like that, I would think that he should be able to, put his soapbox down and his megaphone or a little boom box or whatever he wants to do, just like everybody else. But I guess what I'm wondering is this kind of enforcement done against others who may be proclaiming a different message or panhandling or whatever? Or is it really just targeting religious speech?
Well, you're exactly right. There's a distinction to be drawn between trying to speak at the amphitheater itself, which he's not trying to do, but actually speak well outside of it, in a public park, and so that's what he wants to do. And the law, the way it reads, is that it labels certain speech as protesting or demonstrating. Now, to our knowledge, it's only been applied to individuals like Mr. Olivier and really no one else. But even if you accept the terms as they are in the ordinance, uh, it definitely distinguishes between speech because while it would disallow gay speech, which is just pure evangelism, which I think by quite a stretch they would label that as a protest because he's not protesting anything. He's not protesting what's happening in the amphitheater or anything else. He's trying to share a particular message. But even if you lump it in that way, something that's clearly not covered is someone who wants to talk about a great discount at the pizza shop right down the road, or someone who holds a sign who's supportive, a big fan of someone who's playing in the amphitheater. So they're all speaking. They're all trying to speak in the same area, but he's limited because of what he's trying to say.
So that's the kind of the background facts of this case. This is what really started the whole thing. But in terms of the legal issues involved, it really started to heat up, didn't it? When he tried to challenge the constitutionality of this ordinance. So can you walk us through what happened next?
That's right, Bettina, because it really a very important corollary of these rights that we're referencing here, the right to free speech, the right to exercise your religion, is really the right to have those rights, to be able to protect those rights in court. And so that's what he was trying to do. He wanted to challenge the law because he firmly believes is unconstitutional, so that he can go back out there and speak without fear of being arrested again. But he ran into an obstacle. The court invoked a case that came out in 1994 called Heck v. Humphrey. And it's a doctrine that really has historically been associated with prisoners, basically telling prisoners that if you have concerns about your sentence, you have concerns about the fact that you were found guilty, then your avenue of relief is something called a habeas corpus. That's something that prisoners can pursue if they believe that there's been some type of conspiracy, something went wrong with the process. They can utilize a habeas corpus instead of a 1983 constitutional claim. And there's good reasons for that, for managing the court docket to do that sort of thing. However, it is terribly misplaced, and this is what happened here, is that they applied it to Mr. Olivier's claim. He was never a prisoner. And also his relief is forward looking. He's not trying to revisit what happened to him, the fact that he was even arrested. His concern is he wants to go back and speak.
And so he's kind of caught in this strange catch-22 situation, right? He can't he can't move any way.
It really is a very it is very strange, and it's very regrettable, for him because essentially what the court has told him is that he is forever deprived of his constitutional rights, and he has no basis for ever challenging that deprivation. So it is a very odd catch-22, and it's one that the law, should not recognize.
So where is the case now? Obviously, he's appealed in some way, right?
He did, and, that's been a journey, Alan. We appealed it from the district court to the Fifth Circuit Court of Appeals, which, that's the Court of Appeals, of which Mississippi is a part, and, lost a panel decision. But then we went through a process called an en banc, which is where we're trying to get before all the judges of the Fifth Circuit, and received a very frustrating response to that. That by a vote of 9-8, 9-8, they denied hearing en banc. But we had some very good dissents from that denial, and that really propelled us to seek a cert to the U.S. Supreme Court. And just recently, we received terrific news that the Supreme Court will hear this case.
How widespread are um, conflicts over individuals trying to exercise their free speech and evangelize in public places? I mean, I certainly have heard of cases here and there over the years. Um, it, and I mean, Louisiana, you would think that you're in the Bible Belt. You'd think that it wouldn't be a problem.
Right. Well, Alan, it's actually in Mississippi, which is also certainly a right smack in the middle of the Bible Belt.
You'll have to forgive
And
this Yankee for mixing up.
right. Well, you wouldn't be the first to confuse those two states, but yeah, that your point is well taken, and that is, it's something that is concerning that you would even have this type of thing because we really are talking about fundamental rights, it, where the law is fairly well established that you should have a right to share your views, whatever those views happen to be, in a public park or a public sidewalk. And yet we do consistently see issues like this really all over the country, including the Bible Belt. And particularly because it amounts to the fact that government officials just do not want to hear the message, or perhaps that they've heard from some complaints and they figured that the easiest way to deal with it is to censor the speaker.
So what is the issue that the court is going to focus in on? What is the question presented in this case that will be decided?
Yeah, the question is really the applicability of this Heck v. Humphrey doctrine, this doctrine that would require a litigant to pursue a habeas corpus instead of a constitutional claim in federal court. Is that really appropriate in this context? Where one, you have someone who's not a prisoner. He never had an opportunity to pursue habeas corpus, so that's not even an opportunity for him. And two, someone who's the relief that he's seeking is forward looking. So he's not the underlying context is there's a concern about, well, you don't want federal courts to step on the toes of the state criminal courts, and that we really want consistent judgments. But that's of no concern when someone is pursuing what's known as prospective relief, future looking relief, because you're not trying to change it in any way what happened in a criminal court, but really just trying to regain your constitutional rights. And certainly, if there's any thing that the federal courts are supposed to do, it is to accept these types of cases.
You know, Nate, I see this in a broader kind of principled way as a learning opportunity for us as Americans, right? Because um, our Constitution provides for us to be a liberal democracy, and liberal not in the sense of liberal versus conservative politics, but in the sense that we all have a right to our beliefs, and to speak them freely, to live in peace with our differences. But increasingly in our polarized country, both values and politics and all, um, we want to shut down the other side, whatever the other side is. We have abandoned, to a great extent, we've abandoned our commitment to these liberal principles that you can believe differently than I do. And I think it's a learning opportunity for us to remind ourselves what it is that we value about America. You know, that yes, we all get to live with our different beliefs.
Yeah, amen to that because there's no question about it. If we do not take a stand on something like this, Alan, then we really no longer have a country that we could recognize because it really does have to be founded on the fact that everyone has a right to their own beliefs and to be able to share those beliefs in the public square. And once we lose that, then we really do have to question whether or not we still have a country.
So I know our time's running out, but I want to ask you, you know, as this case moves forward and a decision comes down, what do you hope it will change? What do you hope will change, not just in the law, but also in how, everyday Americans understand their freedom of speech, their religious freedom, their right to a day in court?
It really all the above, Badina, where that people should be able to go without fear and to be able to share their beliefs, share their religious beliefs in public places, knowing that they have a right to do it. They have a constitutional right to do what they're doing. But should the government restrict that in any way, they have access to a federal court to ensure that right. And so I think it's a confidence, is an assurance that I pray would be the result of this decision.
Mm. Thank you so much for your time today, and we wish you all the best going forward with this case.
Oh, thank you very much for having me.
Ellen, as we were talking with Nate just then, I kept thinking back to a conference I was at just a few weeks ago in St. Louis. It was a major church conference. And every morning when I left my hotel room and walked across the road to the convention center, there was a group with a megaphone, with literature. They were robed in white, and they were telling us, the people who were attending this conference, that we were in the wrong, that we didn't know our Bible, we had our prophecy, understanding of prophecy, all messed up, and they were telling us this through their megaphones when I left in the morning and when I returned in the evening. And I have to say, no one really turned an eyelid on it. They just walked on by, I took the literature many times, but I often thought, this is American freedom in action. The fact that I can attend my conference and they can stand outside and express their views about me and my beliefs, and we can do that in a way that's peaceful. I think that goes to the heart of what it means to live in a free, liberal democracy.
And yes, I agree, and I think it's so central to who we are. Um, I have to take this in a somewhat humorous vein, Bettina, because whenever I think about public preaching, I'm reminded of a scene in the movie, um, I think it was called 2013, about, the Mayan prophecy of the end of the world. So it's one of these apocalyptic movies, and there's earthquakes, and the sidewalks are, are crumbling and buckling and rolling and what have you. And you've got this kind of chief of staff kind of guy in the control room with 10,000 monitors, and you see on one of the monitors the guy with the megaphone and the sign that says, repent for the end is near, right? And the, obviously skeptical, cynical, hard bitten chief of staff, politician kind of guy in the control room says, and this is almost, it could be a direct quote, "I never thought the wackos with the signs would be right after all." But for any of us who grew up in a city, I grew up in New York, the so-called wackos with the signs they're part of life. They're part of
Mm,
the,
yeah.
the rhythm and the color of the city. And it would be very different without them. Whatever you may think of their message or their sanity, uh, it would be very different without uh, people having the right to get up on their soapbox, whether it's religion or politics or, whatever. That's part of what makes America.
Absolutely. I mean, I'm just proud to belong to a country where unpopular speech is protected. I mean, that's what these constitutional protections are for. You don't need to protect popular speech. It's the annoying speech, the irritating speech, the speech that we don't particularly want to be confronted with. That's what needs the protection.
Well, and we have already talked on this show about efforts to curtail speech that is not welcomed by the government. And we're going to need to return to that theme again. Hopefully, not again and again, but it does seem to be a consistent threat.
It does indeed. Well, thank you everyone for joining us for this episode of Just Liberty. Until next time, I'm Bettina Krause with Alan Reinach. And remember, eternal vigilance is the price of liberty.